Hello, and welcome to a virtual training about dispute resolution options for K-12 students with disabilities by myself, Sarah Peelsticker, and my colleague, Emily Harvey, attorneys at Disability Law, Colorado. This video is intended to be educational, but is not legal advice. We also want to thank our partner, AdvocacyDenver, for providing Spanish translation of the materials and presentation today. In this video, we are going to cover several topics. First, we will discuss the importance of this topic. Then, we will give a very brief overview of informal and semi-formal dispute resolution options that are available. After that, we will spend a bulk of our time discussing formal administrative dispute resolution options that are available. Lastly, we will briefly discuss lawsuits for education-related matters, but you should always consult an attorney first if you are considering filing a lawsuit. So, why is this topic important? There are many differences between the various dispute resolution processes, making it difficult to figure out what next steps to take or what processes to look into. We're hoping through this video that you will better understand the options that are available and what the differences between each process are. For example, different processes have different laws over which they have jurisdiction. So, some processes may only work for violations of the Individuals with Disabilities Education Act, or IDEA, while others are only good options for violations of Section 504 of the Rehabilitation Act. Different processes also have different deadlines, requirements for filing, and requirements for opening a complaint for investigation. Additionally, there are different processes for investigating claims, timelines for decisions, and potential remedies available based on the process you choose to pursue. We'll start with briefly discussing what informal and semi-formal dispute resolution options are available. First, you can request an Individualized Education Program, or IEP, or Section 504 meeting at any time if you think there are important items to discuss. You do not need to wait until the annual review meeting to bring up issues that are important for the IEP or Section 504 team. You are welcome to bring an advocate, friend, or family member to any IEP or 504 meeting. Next, we recommend communicating your concerns to someone within the school, such as the principal or school counselor. It is important to do this in writing so that you are able to keep a record of this communication. After that, it can be helpful to communicate your concerns to someone at the district level, such as the special education director for your district, the Section 504 coordinator, or the superintendent. You can find your district special education director on the Colorado Department of Education, or CDE's, website. There may be a Section 504 coordinator for your school at the school level as well, but at the very least, the district is required to have one. Again, it is important that these communications are in writing. Lastly, you can follow the district's Section 504 grievance procedures, which should be on their website or can be provided by the Section 504 coordinator. We are not going to be going into much more detail to this informal and semi-formal dispute resolution options in this training, but we do recommend them as a starting place for parents and guardians when a dispute arises. Children are in school for many years, and it can be helpful to keep in mind that this is a long-term relationship. We will now move on to what we are covering in the remainder of this video, and that is the formal administrative dispute resolution options. We will be covering facilitated IEP meetings, mediation through CDE, state complaints to CDE, due process complaints to CDE, complaints with the U.S. Department of Education's Office for Civil Rights, or OCR, complaints with the U.S. Department of Justice, or DOJ, in either the Disability Rights section or the Educational Opportunity section, and complaints to the Colorado Civil Rights Division. When discussing the complaint options mentioned on the previous slide, for each we will discuss the process and timelines involved, issues that can be addressed, pros and cons of that complaint process, as well as potential remedies for each complaint process. That is a lot to cover, so take breaks as you're watching this if you need to. First up, we will discuss facilitated IEP meetings. Facilitated IEP meetings are available through CDE if your child has an IEP. They can be requested anytime on CDE's website, but it is important to keep deadlines for other complaint options in mind if you think you might want to pursue other options. Facilitated IEP meetings are voluntary on both sides, so if you request one, the school district does not have to agree to it, and vice versa. If the meeting is agreed to by both sides, a neutral third party will come in to facilitate the meeting. The facilitator will have no decision-making power, but will be there to help keep everyone on track. These meetings can last an hour or several hours depending on the needs of the child and the team. Similar to other IEP meetings, all required IEP team members must attend, as well as other relevant members who are invited by the parent or school district, unless specifically excused in writing. The goal of this meeting is to have an updated IEP for the child. Issues that can be addressed in a facilitated IEP meeting are essentially any issues that can be addressed in typical IEP meetings. For example, you can discuss services in a child's IEP, including special education services, occupational therapy, physical therapy, speech therapy, and transportation. You can also address things like the least restrictive environment appropriate for the child, the student's goals, eligibility, and manifestation determination reviews. So what are the pros and cons of a facilitated IEP meeting? The pros are that it's free, it's minimally adversarial and student-centered, you can address any concerns related to a child's IEP, and the team could potentially develop a plan for compensatory services if they are needed. Cons of a facilitated IEP meeting are that the school district can say no to having one, and no formal decision will be made regarding any alleged violations. You also can't recoup for attorney's fees if you hire an attorney for the meeting, but it is not something that you necessarily need an attorney for, as it is easy to navigate and not very adversarial. A facilitated IEP meeting may be a good place to start depending on your individual situation. Next, we will look at mediation through CDE. Mediation is a process available through CDE for disputes if your child has an IEP or if you think your child should be eligible for an IEP. Similar to a facilitated IEP meeting, mediation may be requested at any time on CDE's website, but it is again important to keep other complaint option deadlines in mind because those are not necessarily on pause, also referred to as being told, while you are attempting resolution through mediation, unless you have already filed a state or due process complaint. Mediation can also be requested after filing a state or due process complaint, and the complaint forms will ask if this is a process you are interested in when you are filling out those types of complaints. While you can request mediation after filing a state or due process complaint, you do not have to file a complaint to request mediation. Mediation can be requested by either a parent or guardian with educational decision-making or by the school district and is voluntary on both sides, so both parties have to agree to participate. Once one party requests mediation, CDE contacts the other party to see if they are also interested in mediation. And if both sides agree, a neutral mediator will be assigned. Then, the mediator will reach out to the parties to schedule mediation at a mutually agreeable date, time, and location. Mediation can be done virtually or in person, and this is something you can discuss with the assigned mediator. Prior to mediation, everyone signs an agreement to mediate that includes a statement that everything discussed during mediation is confidential. Mediation is not usually attended by the entire IEP team, but rather relevant members of the IEP team and district-level staff. At the start of mediation, the parent or one of their representatives is usually given an opportunity to explain why everyone is at the table. It is best to focus on moving forward and supporting the student and what would help everyone get there rather than focusing on what went wrong. Then, usually the family and the school district will split into separate rooms and the mediator goes back and forth between the rooms to discuss different topics. This is also known as shuttled mediation. If everyone ultimately agrees on terms, a settlement agreement is developed and signed. If there is an impasse, a parent may pursue complaint options, but everything discussed in mediation must still be kept confidential and not shared in additional complaints or proceedings. It is not uncommon for mediations to last a full 8-hour day, though they can sometimes be resolved in less time. Be sure to bring snacks and drinks if you are participating in mediation that's in person. You can use mediation to address a variety of issues involving special education and related services, including identification, evaluation, eligibility, development and implementation of an IEP, least restrictive environment, discipline, and/or any other matters that are protected by the IDEA and ECEA, which is our state special education law. You also can potentially address any concerns you have that relate to the Americans with Disabilities Act, or ADA, and Section 504 in mediation. It is usually wise to raise these concerns at mediation in addition to other concerns, because if you sign a settlement agreement, you will likely be asked to waive any claims relating to the facts and issues you have raised, and this may include claims related to the ADA and Section 504, as well as other laws such as Title IX. This means any settlement agreement you agree to will need to provide you with what you want in order to be willing to give up any of those other claims. It is also important to remember that if you have another complaint pending elsewhere, such as with OCR, you can agree in a settlement to request withdrawal of that complaint, but OCR still ultimately decides whether or not that complaint will be dismissed. Some of the biggest pros of participating in mediation are that it is free and less adversarial than going through a full complaint process. Also, through mediation, parties have the power to develop settlement terms that work best for them, and they can think creatively about how those settlement terms look. For example, you might be able to look at a summer camp for compensatory services, or be able to add a certain behavioral strategy that may not otherwise be able to be ordered in a decision from a full complaint process. Similar to facilitated IEP meetings, a con of this process is that you cannot recoup attorney's fees if you bring an attorney with you to mediation, but this is another process that you don't necessarily need an attorney for, as it is generally straightforward and not as adversarial of a process. Another con of mediation is that there will be no formal decision as to whether or not the alleged violations were in fact violations, and if a settlement agreement is signed, you will have to waive all claims up until the date of the agreement. This basically means that you agree that the settlement agreement resolves the claims that you have raised at mediation, and you cannot pursue a further action on these claims. If you do not reach a conclusion in mediation and no settlement agreement is signed, then you can still pursue other avenues for these claims if you are within the deadlines necessary. If the settlement agreement is breached, enforcement is through filing an action in state court for a contract dispute. However, if the terms of the agreement were put into your child's IEP, then you can follow relevant dispute resolution process related to IEPs. Mediation is strictly confidential and usually includes a clause that you cannot even discuss the settlement terms with the exception of setting up any services or paying for those services. Lastly, if you receive any money as part of a settlement, you may have to pay taxes on that money. Some potential remedies that you can pursue during mediation are revisions to school or district policies and procedures, training for staff, reevaluations and functional behavior assessments, and compensatory services. Compensatory services can include services directly from district staff, reimbursement for things like services from private providers, camps, therapeutic writing, etc., or a monetary sum that you can use for services and select your own providers. Remedies provided in mediation are not necessarily limited to what might be ordered through a complaint process, because by coming to an agreement in mediation, the district is avoiding having to go through a full investigation, and that is something of value to them, as it saves them time and resources. Now, we will talk about state complaints to CDE. State complaints are available for disputes if your child has an IEP or should have been identified as being eligible for an IEP, so violations of the IDEA or ECEA. This process is also available for violations of Colorado's Protection of Individuals from Restraint and Seclusion Act, or the PPRA. State complaints can be filed by anyone, so a parent, advocate, attorney, or any other entity may file a state complaint if they think a violation of the IDEA, ECEA, or PPRA has occurred. Your identity is not confidential to the school district if you file a complaint. State complaints must be filed within 1 year of the alleged violations, and if opened, the investigation will not go beyond 1 year in its scope. Complaints must be either mailed or hand-delivered to CDE. Email copies will not be accepted, and a copy of the complaint must also be provided to the special education director of your district when you file. Again, this person's information can be found on CDE's website. The form and requirements for state complaints can also be found on CDE's website. The form is very parent-friendly as far as how it is laid out and what information you need to include. You do not have to make legal arguments in your complaint, you just need to present your story. The standard for opening an investigation is whether the facts as alleged would be a violation of a law that CDE enforces, so the IDEA, ECEA, and PPRA. Mediation can still be requested by you or the school district after you file. Once a complaint is received, CDE will assign a state complaint officer, or SCO, to each complaint. Each SCO at CDE is an attorney. After you file a state complaint, the SCO will determine whether or not to open your complaint for investigation. If your complaint is opened for investigation, the school district is given an opportunity to submit a written response to your complaint. The person who filed the complaint can then submit a written reply to the school district's response. This is not required, but serves the purpose of allowing you to address anything new or different based on the response. The purpose of the reply is not to rehash what was already in the response. After that piece is complete, the SCO will investigate the complaint by reviewing records and conducting interviews. While you are welcome to provide them with any documents necessary, it is not required as the SCO will request all necessary documentation from the school district. Within 60 days of the complaint being received by CDE, the SCO will issue a decision and order corrective action if any violations were found. We will discuss what corrective action might look like in a later slide. Then, CDE will monitor the ordered corrective action until all requirements are met by the district. State complaints may not be appealed, but the district or parents can still file for due process after a state complaint decision, but this will be a de novo review, meaning that they will not look at the state complaint decision or investigation in this process. In a state complaint, you can address any concerns that relate to the IDEA or ECEA, including child find and identification, evaluations and reevaluations, eligibility, development and implementation of a student's IEP, provision of FAPE, least restrictive environment, and discipline. You can also address concerns relating to the use of restraint and seclusion in schools and concerns related to records access, confidentiality, and personnel qualifications. When addressing concerns related to the use of restraint and seclusion in schools, this is limited to the requirements in IDEA and state law, which can be found on CDE's website. CDE will not analyze claims under the ADA or Section 504. The pros of doing a state complaint are that it is a fairly quick resolution. Decisions have to be issued within 60 days, so there is a quick and mandated turnaround that is not as clear-cut in other complaint options. Additionally, CDE will order specific compensatory services if they determine a child is owed these services. For example, they may say a child is owed 100 minutes of speech services. Other complaint options do not go into as many specifics. Lastly, whether or not violations are found, state complaint decisions are public and will be posted on CDE's website in a redacted format. Since the decisions are public, you are allowed to share them and discuss them freely. Similar to the last couple of processes we discussed, a con of the state complaint process is that you can't recoup attorney's fees. But again, you do not necessarily need an attorney for this process, as the form is very straightforward and the SCO will be guiding the parties through the process. Another con is that you cannot address potential violations of the ADA, Section 504, Title VI, or Title IX through this process. Lastly, if a due process complaint is filed later on the same issues, the issues addressed in a state complaint could become moot and you could be forced into due process, which is a much more arduous process. However, some issues may be preserved in the state complaint if they cannot be addressed in due process. Potential remedies that you may expect from the state complaint process are revisions to district or school policies and procedures, training for staff, reevaluations, and functional behavior assessments, and compensatory services. Like we mentioned, if they are deemed necessary, a state complaint decision will usually order a specific type and amount of compensatory services based on a qualitative analysis. So, these services are not determined on a minute-for-minute basis, but rather the SCO will look at what is needed to put the child in the place they would have been had the violation not occurred. Lastly, a potential remedy of a state complaint might be a full program audit. However, we have only seen this once, and it was with a state entity.
Next, we will discuss due process complaints that can be filed with CDE. Due process complaints are an option available for disputes if your child has an IEP or if you think your child should have been identified as being eligible for an IEP, but is different from the state complaint option discussed previously, and we will go into more detail as to why. Due process complaints must be filed within 2 years of the alleged violation and may be filed by a parent, guardian, or administrative unit such as a district, BOCES, or state-operated program. Complaints must be mailed or faxed to CDE. They cannot be emailed, and you must also provide a copy to the district. A due process complaint form and more information about what needs to be included are available on CDE's website. Once a complaint is received, an administrative law judge, or ALJ, is assigned to the complaint. The responding party then has 10 days to file a written response. Within 15 days of receiving the complaint, the ALJ must convene a resolution meeting with the parent or guardian and relevant members of the IEP team. If the parent has an attorney, they will also come to this meeting, and so will the school district's attorney. If the parent does not have an attorney, the school district cannot have their attorney present. Then, within 30 days of receiving the complaint, the ALJ will schedule a pre-hearing conference where the parties will discuss logistics of the hearing, such as how many witnesses each side will have. Still requests mediation after filing a due process complaint, and that process would follow the practices and guidelines laid out previously. A decision will be issued 75 days after the complaint is filed, unless the timeline is extended. If the complaint concerns a disciplinary change of placement, which is a removal from school that is greater than 10 days for a code of conduct violation, or disagreements about manifestation determination, the hearing will be expedited. In these situations, a hearing must take place within 20 school days of the complaint being properly filed, and a decision must be issued within 10 school days of that hearing. If the school district is not following an order from a due process decision, a state complaint may be filed to request an investigation. Due process may be appealed to state or federal court, which may make it months or years until you get a final decision. Issues that are best suited for due process complaints are alleged violations of the IDEA or ECEA about identification, evaluation, or educational placement of a child with a disability. You can also allege violations of the provision of a free and appropriate public education, such as a special education program or supports and services provided to the child. A main pro of filing a due process complaint is the stay put provision, allowing a child to remain in the placement they are currently at until a decision is reached. Additionally, due process complaints can have a fairly quick resolution unless the decision is appealed, in which case the process may drag on for some time. Also, you can recoup attorney's fees in this process. Lastly, this process is the only way under the IDEA to exhaust administrative remedies if you wanted to pursue a lawsuit. Some cons to due process complaints are that you can't address systemic issues, as the remedies are typically individual. You also cannot address concerns related to Title VI or Title IX if there are intersectional issues. Also, for this process, you are more likely to need an attorney, as it can be cumbersome and more like a court proceeding where you will have to submit evidence, call and question witnesses, and provide objections. This process can be very adversarial and strain relationships between the district and families. You can also be ordered to pay the district's attorney's fees if your claim is considered to be frivolous in nature. Some potential remedies that you may get out of filing a due process complaint are compensatory services, tuition reimbursement, and a specific placement ordered. This is the only process of those we discussed where tuition reimbursement and specific placement are available as remedies. The U.S. Department of Education's Office for Civil Rights also has a complaint process. We call these OCR complaints. You do not have to have a lawyer to file a complaint with OCR. An OCR complaint is available for disputes involving Title II of the Americans with Disabilities Act, or ADA, regardless of funding, and Section 504 if the entity receives federal funding from the U.S. Department of Education. You must also allege a violation of one of the laws OCR enforces. OCR complaints must be filed within 180 days of the alleged violation. They may be filed by anyone, and they are sometimes able to keep a person's identity confidential, but complaints may not be filed anonymously. Complaints can be filed online, by email, or through the mail. The complaint simply needs to include the facts that you are alleging. You do not have to include legal arguments. You should get a letter or email confirmation acknowledging that OCR received your complaint. The complaint is then assigned to an investigator who may or may not be an attorney. The investigator decides whether the complaint is timely and what, if any, allegations they will open for investigation. OCR must review every complaint filed with them to make this determination. When OCR sends you a letter explaining what allegations they are going to investigate, the school receives a similar letter along with a data request. This is the first time OCR puts the school on notice that a complaint was filed. If OCR doesn't open your complaint for investigation, OCR never notifies the school about your complaint. It's important to know that with OCR, they will likely dismiss your complaint if you have already raised your concerns through another process, even an internal school grievance process, and are waiting for a decision from that other process. If this happens, you can refile your complaint within 60 days of receiving the decision through the other process if you're not satisfied with the outcome of that decision. OCR also has a mediation process, and you can request mediation at any time. Mediation is voluntary on both sides, so both you and the school district would have to agree to attempt resolution through mediation in order to proceed with this process. If both sides agree to mediate, a different OCR staff person will be assigned as the mediator. This won't be the same person who is assigned as the investigator, and the information obtained in mediation conversations must remain confidential and isn't shared with the person who is investigating, even if mediation is unsuccessful. If you are able to successfully mediate, this results in a settlement agreement between you and the school. If you successfully mediate and there is a breach of the agreement, you can refile your OCR complaint. Stepping back into OCR's investigation process, they generally request documentation to review and conduct interviews with relevant people. OCR can resolve a complaint through various mechanisms, including dismissal or mediation, as we've already discussed. They can also resolve through a rapid resolution process, a voluntary agreement with the school prior to completing an investigation, or a complete investigation with either a violation or no violation finding. There is never a guarantee that they will find violations, but if they do, they negotiate a resolution agreement that includes specific things the school needs to do to correct the violation. If they resolve the complaint through voluntary resolution prior to a full investigation, this also results in a resolution agreement that likely requires similar things they would require if violations were found, but there won't be a letter specifically stating or outlining any violations. If there is a resolution agreement, OCR monitors the terms of that to make sure the school does all the things required in it. In these processes, OCR is the one determining what the remedies will be, not you as the complainant. You can always tell OCR what you would want to see in a resolution agreement, and they may consider it. One of the more frustrating aspects of OCR complaints is that there are no strict timelines. This means a complaint could be resolved in 2 months or 2 years. Generally, more complex systemic issues take longer than individual complaints for one student, though those can also take a long time. As we said, OCR has jurisdiction over Section 504 and Title II of the ADA, so these are the laws they are looking at when deciding if there were any violations. Some examples of issues you can raise in OCR complaints include failure to evaluate or reevaluate, failure to individualize or implement a 504 plan or IEP, failure to follow grievance procedures, bullying, different treatment, disparate impact, retaliation, extracurriculars, denial of equal enjoyment of goods and services, and failure to accommodate a parent's disability. OCR also has jurisdiction over Title IX, which protects against discrimination based on sex, and Title VI, which protects against discrimination based on race or national origin. This means you could also raise claims based on sex, race, and language access for those who do not speak English as their first language. Pros and cons of OCR's complaint process. The first being that you can address those intersectional claims based on sex, race, and national origin. OCR complaints can also potentially address systemic concerns such as policies that are negatively impacting a whole group of students with disabilities. School staff can file OCR complaints and ask that their identity remain confidential. OCR may not be able to guarantee confidentiality, but it is worth talking to them about it if you are a school staff person considering filing a complaint on behalf of the students you serve. There are a number of cons with OCR complaints as well. One of those being that there are no strict timelines, which I already mentioned. OCR also controls whether they believe a case is appropriate for mediation, and they don't have jurisdiction over the IDEA, so allegations are not analyzed under those requirements. Unlike state complaints, where specific compensatory services are ordered if a violation is found, OCR defers to the IEP or 504 team and tells them to reconvene to determine if and what compensatory services the student is owed. Finally, monitoring of resolution agreements can last years, and sometimes the specific things the school is required to do don't happen in a timely manner. If OCR finds violations, there are various potential remedies that might be included in the resolution agreement. They may require that the IEP or 504 team come together to discuss whether compensatory services are owed, and if so, the amount and how they will be delivered. They may similarly require a meeting to discuss remedial measures. They may also require that the team report back to OCR about this meeting and the decision that was reached. OCR can also require revisions to policies and procedures with their input into what is appropriate before it is finalized. There may also be staff or student trainings, climate surveys, new programs, and the opportunity for a student to reapply or re-enroll in a program. This is not a complete list, but some examples of remedies you may see in a resolution agreement. Yet another option is to file a complaint with the U.S. Department of Justice, which we'll refer to as the DOJ. You do not need a lawyer for this process either. The DOJ complaint process is available for disputes if you believe one of the laws they enforce has been violated. They have jurisdiction over Section 504 and Titles 2 and 3 of the ADA. The DOJ does not have a strict timeline for filing, but they are more likely to investigate more recent issues. Anyone can file a DOJ complaint: teachers, parents, students, administrative staff, other members of the public. They have an online complaint form, or you can submit a complaint by mail or fax. The DOJ does not have an obligation to review and respond to every complaint filed with them, and they can refer complaints to other agencies. For example, they sometimes refer complaints to OCR or the Equal Employment Opportunity Commission. In our experience, the DOJ does fairly significant research into the issue before opening an investigation, and they do not send notification letters like some of the other processes. Their process isn't very transparent, and we have sometimes waited years to hear anything from them. However, we have seen the DOJ looking as far back as 3 years for complaints about the use of restraint and seclusion in schools, and that's a lot further back than you can go with some of the other complaints. Based on our recent experience, it seems that the DOJ is more likely to look into systemic issues rather than individual complaints. They also have a mediation program, so your complaint could be referred to that voluntary process. If the DOJ finds violations, they issue a letter of findings that explains the violations and what steps need to be taken to remedy those concerns. The DOJ then attempts to negotiate with the entity. The person who filed the complaint isn't part of this negotiation or the resulting settlement agreement if one is agreed to. Terms of these agreements often include reporting to the DOJ for a number of years. If the DOJ is unable to negotiate a settlement agreement with the entity, they can pursue litigation instead. This lawsuit would be the DOJ versus the entity, and the person who filed the original complaint is not generally a party in the case. The issues you can potentially address in a DOJ complaint are fairly broad. Examples include failure to evaluate or reevaluate, failure to individualize or implement a 504 plan or IEP, bullying, different treatment, disparate impact, retaliation, extracurriculars, denial of equal enjoyment of goods and services, and failure to accommodate a parent with a disability. The DOJ also has jurisdiction over the laws that protect against discrimination based on sex, race, and national origin, so complaints of that nature can also be raised. Currently, it seems that the DOJ is most interested in school issues that involve restraint and/or seclusion and residential programs for youth in foster care. Individual complaints and a systemic school choice complaint we filed were both referred to OCR. Some pros of the DOJ complaint process are that you can address those intersectional issues. There's potential for massive change if they investigate and if you're patient. And the DOJ has the power to file a lawsuit if it comes to that. Some cons of the DOJ complaint are that they don't have to look into every complaint they receive. The process is not very transparent. The person who filed the complaint isn't involved in negotiations, and investigations can take years. Some examples of remedies we've seen from the DOJ are revisions to policies and procedures, including a full ban of seclusion, which is further than any other administrative entity has gone. Limitations around the use of restraint and requiring counseling for students who were restrained. They have also required designated staff to collect and analyze data, staff training, and even hiring new positions. The final administrative complaint option we're going to discuss in this video is a complaint with the Colorado Civil Rights Division, or CCRD. The CCRD has jurisdiction over the Colorado Anti-Discrimination Act, which is a state law similar to the ADA. The CCRD process is available for people with disabilities who believe CAUTA has been violated. The complaint must be filed within 60 calendar days unless your issue is related to employment, and this date is not the date you submit it to CCRD, but the date they follow up and do an intake with you. This means you should submit the complaint well before the 60-day mark. In our experience, they do seem to prioritize responding in order to get this scheduled fairly quickly. More information can be found on their website. Like most of the other processes, CCRD has a mediation process that is also voluntary. If not resolved through mediation, the flow is that the person files a complaint, the entity the complaint was against files a response, and the person who filed the complaint is given an opportunity to file a rebuttal. The rebuttal does not need to restate what was in the complaint. It just needs to respond to anything in the response that the person wants to clarify or dispute. CCRD then reviews documents and interviews relevant people. After the investigation, they issue a cause or no cause finding. If there is a cause finding, there is mandatory conciliation, which is like mediation, but not voluntary, and the complainant has a little more leverage since there has been a violation finding. If there is a no cause finding, you could potentially still file a lawsuit, but you need to be aware of the exhaustion requirement in education cases, which could preclude you from doing this until after you go through the due process procedures that we previously talked about. Issues you can address in CCRD complaints include denial of equal enjoyment of goods or services, different treatment, disparate impact, and retaliation. While CCRD is available, we generally recommend one of the other processes because of the laws the other entities enforce and their familiarity with education-specific requirements. However, it's worth considering depending on the specific issues and concerns you are considering raising in a complaint. Similar to some of the other processes we've discussed, CCRD has jurisdiction over laws that protect against discrimination based on categories other than disability. Specifically, CAUTA protects against discrimination based on gender, gender identity, sexual orientation, creed, color, national origin, race, and marital status. If the complaint is resolved through conciliation, which is required after a violation is found, the complainant does have some say into the remedies. Some cons of the CCRD process are that you have to file a complaint against a school within 60 calendar days, again, unless your issues involve employment. They only analyze claims based on CAUTA. Investigators don't necessarily have a lot of familiarity with schools, and there's not a high rate of success generally when it comes to complaints with CCRD. The last dispute resolution option we're going to discuss is a lawsuit. The main takeaway on this is to call a lawyer. In cases involving elementary and secondary education, exhaustion may be required before you can file a lawsuit in court. This means you would have to go through the due process hearing procedures that we previously discussed before you could pursue a lawsuit. The ADA and Section 504 do not require exhaustion, but courts have required people to go through due process before filing a lawsuit, even in cases where the IDEA has not been mentioned because the judge believed the claims could have been brought under the IDEA. The issue of exhaustion is too complex to discuss in detail in this video, so just remember to call a lawyer. Lawsuits are also time and resource intensive, and you will most likely want to hire an attorney to assist you through this process. Please note that this presentation is intended as educational but is not legal advice. While we covered many aspects of the complaint processes, we did not speak to specific situations. If you need individual help, please call 303-722-0300 to access our intake process. You can also submit your information online by visiting our website. We also have a lot of information about disability rights on our website at disabilitylawco.org/resources/fact-sheets. Thank you for watching this video, and we hope it is helpful as you engage in self-advocacy. Please see the notes for links to a list of acronyms and websites mentioned throughout this presentation.